I hope you people have had your lunch and now you will be able to sit. I don't know how much you will be able to sit for the next sessions, but be attentive because we are going to have a session on anti-ragging, which is very important for you. Later, when you join the institute, you have to fill a form. And after that, we will be having a POSH session. You will be getting some information on the POSH. So be seated. We are going to start with our next session. Thank you.
Let us now start with our next session, for which I invite Assistant Professor Deepika Changani, who's an enthusiastic law faculty of KPM to enlighten us on anti-ragging. Deepika, floor is yours.
A very good afternoon to all of you. My name is Professor Deepika Changani. I'm an assistant professor of law. And when I was dwelled up with this task of giving you an importance on the anti-ragging awareness, I thought that since you are an incoming law students, we should make it a little law specific. But I also need to tell you few things which we miss out as freshers. It was a way long back when I was a fresher like you in Rajiv Gandhi National University of Law. And I was eventually taken up in a garden-like area where my seniors were actually having an introductory session. I thought that this introductory session will be just like a normal session. I will be asked my name, from where I am, and all of those things. Slowly and steadily, the session went into stereotypical notions. We were made to dance on the themes of the state we are representing. It became so awkward that when our Vice Chancellor came to know about it, he immediately came and condemned the session. The least was that I had no idea that I was inadvertently a part of a ragging process. Worst case scenario, my seniors also didn't know that they were ragging me. So I guess it's very important for us that when we are looking forward to an anti-ragging awareness session, it is very, very significant for us to understand that what could be a casual behavior and what is a behavior which is prohibited in law. So before I go into technicalities of what NMIMS actually does by, I thought that I will just take you that in the state of Maharashtra also we take ragging as a very serious affair. In the Maharashtra Anti-Ragging Prohibition Act, you can see that ragging has been explained in very, very theoretical context what actually happens at universities, law schools, and other premises. So as a fresher, if you come across any kind of instance where there is some kind of disorderly conduct from your senior, they are trying to do a very rash and inorderly behavior with you, there is something that you need to take the office into consideration, you need to report it. And if you are even slightly bit confused, I want you to remember this session in the first slide that you can actually, as a law student, you can go to the Maharashtra Anti-Ragging Act and then you can see that, okay, there is a certain kind of structuring which is done to ragging. And if you see in the next part, it talks about prohibition and penalty also. Since you might have already undergone the notorious process of entrance examinations, you might have gone with the specifics of criminal law as well. So it's very important for you to understand that ragging and anti-ragging process are not just some theoretical constructs in law, they are properly recognized criminal offenses as well. So if NMIMS as an institution of academic excellence come to know about a process where you are facing a behavior which actually fits the criteria under this particular act, then it is actually punishable by law. So please understand and take this process with an utmost sincerity that if you were a delusional and an oblivious fresher like me, and if you think that you don't know that what is happening to you is some kind of an upsetting behavior, you should at least put it forward to your faculty members who can make you more aware about whether this behavior actually eventually fits into the process of anti-ragging. Going forwards, if you can go to the NMIMS official website, you will see that they have actually taken up reference from the Supreme Court guidelines on the anti-ragging. And they have structurally defined that an anti-ragging process eventually involves a lot of things which have evolved over time. I think there are a lot of cultural differences and age differences, generation differences, but objectively, the Supreme Court of India has structured a notion as to what should be considered as a ragging behavior. So, firstly, if there is any kind of rowdy or undisciplined activity which you come across, which specifically include you as an individual, if you are looking towards something that a senior or anybody is asking you to do an act which you think is not particularly correct, you think that this is something which is not sounding correct to you, that can also be an initiating part to understand the ragging. The next one is that where you think that there is a pressure onto you to create an activity which will disrupt the academic fabric of the law school or NMIMS in general, so that also can be initiating factor to understand. The next one is, which is very, very serious, which is exploiting the fresher. This particular 2006 judgment focused on what freshers eventually go through. Because as you cross the first year mark, you become generally aware about what is acceptable at the law school, what is not acceptable, what is just a casual behavior, what is not a casual behavior. So please understand that there is a Supreme Court ruling specifically for freshers. So you should, and that is already notified at the NMIMS website. So the institutionalization of anti-ragging awareness is far more severe. So you should not feel abandoned in this process that I'm facing something, but I don't know who to report to this. Also, if there is any kind of financial extortion which is done to you, if there is someone who is telling you that, please give me money, or they are just extorting it out from you, then that is also something which you can actually report. Now, the premise is that how you can eventually report it. So the first thing you need to understand that as a part of the orientation process and you becoming the incoming law students at that law school, you will be made to actually sign an undertaking, which will be an online undertaking. Please do not confuse this online undertaking as just a mere process at NMIMS. It's a UGC mandate. It's a university mandate on NMIMS to make sure that as freshers you actually fill this online undertaking, which is a very, very big necessity. You will also come across in the law school the posters which are shown to you on the screen. That is also a mandate by UGC. And also UGC has a zero tolerance policy for ragging. So that is automatically implemented in the state act, which is the Maharashtra Act, which I just showcased you. So unlike your other activities at law school, which may or may not be institutionalized, please understand ragging behavior has a huge framework in the background, which works to eventually deal with such scenarios. So if you are coming across any of those instances, and even if you think that your friend is coming across any of those instances, please ensure that you report this to the law school. It's very, very important. Because until and unless you don't make the first step, it will be difficult for NMIMS and the School of Law to address those grave concerns. Now, going forward, there are a few things which I thought that I will tell you that you might be slightly confused that, okay, I may have a certain comfort zone with a certain professor. Should I tell this person? Should I tell that person? So please understand that nearly everyone at NMIMS School of Law is actually trained in the process of how to tackle up ragging cases. So you should be eventually feel free to actually talk it out to someone, and they will automatically streamline the process to you if God forbid you witness any of such incident. We also have an anti-ragging cell committee, and which actually takes up and institutionalizes these concerns. Also, please understand that CCTV cameras are everywhere. They are in the classrooms, they are in the corridors. So if you are worried that whatever happened to me, which was a very unfortunate incident, could not get recorded, obviously for a lot of reasons. So you don't need to worry, the evidentiary record will be already in place. There will be an access to CCTV cameras, so you don't need to worry that how will I put it out, whether it will just look like an allegation or not. No, it won't look like, because we'll cross-verify it with the CCTV recordings. The last thing is that you need to understand that when you are actually reading up basics of criminal law during your CLAT preparations or other exams, there is a word deterrence which is used. So considering that how ragging is recognized as a criminal offense, you need to understand that what is the punishment which is generally attached if somebody is convicted of ragging. So apart from the UGC mandate on the zero tolerance policy and the Maharashtra Act, you are actually looking forward to an accurate case where you are going forward for cancellation of admission. So please understand that the process in which you are indulged, unfortunately, is taken up very seriously, and there are a lot of instances which are taken up into consideration, which can eventually lead to cancellation of admission. Now, as a law student, cancellation of admission might look just like a regulatory process to you, but please understand that the cancellation of admission is recorded to the appropriate authorities and it becomes a permanent mark on that student's CV. So it's a very, very serious concern. And at times, you might come across a confusion between a casual behavior and a ragging behavior. For that, we as faculties of law are here. We also have other faculties from other fields as well. And you can connect with any one of us and you can actually get a clarification. But please do not be that student of law who knows that they have been oriented on this part of ragging and anti-ragging processes and they still are not coming up on the front and actually sharing it with the necessary authorities so that a proper concern should be taken. Also, the rationale of sharing the anecdote with you is because I have come across a lot of first year students who are generally not aware as to what is a ragging behavior and what is a casual behavior. So if you are also confused, you should definitely talk to your faculty members here who can help you with it. But please take that NMIMS in along with the notion of UGC has a zero tolerance policy for ragging. So it's completely prohibited. There will be no ragging on the campus. Okay, so that's all from my side. I hope that you might have a little bit of orientation on this, but still if you have any confusions, you can reach out to us and we can genuinely help on in every bit of it. Though, as your well-wisher, I would always wish that you do not encounter such a behavior in the first place. Thank you so much, guys. Thank you.
Thank you, Deepika ma'am, for a wonderful session on anti-ragging, and I hope our students will maintain our environment very healthy and happy. And now, following the session on anti-ragging, I now request Dr. Aksha, Area Chairperson, LLM Program, to have a session with us on POSH, that is Prevention of Sexual Harassment. Dr. Aksha, please take the stage. Thank you.
Thank you, Dr. Pramila. Hello, everyone. My name is Dr. Akshaya Desai, and I work at Kirit P. Mehta School of Law. Today, I will be discussing about Protection of Women from Sexual Harassment Act 2013. As we all are aware that POSH, that is Protection of Women from Sexual Harassment, is one of the important elements of everywhere where women are going out to either study or to work. So as just stated that it is related to women and their protection from any unwelcome sexual behavior which is happening outside their houses. So to begin with, I'll just explain you a few things which amounts to sexual harassment. So first we're going to talk about the Indian law on sexual harassment. So in sexual harassment actually is a very broad term, and in various countries it is considered differently. But over here we are going to talk about India and how we perceive it from our workplace point of view. So in the Indian Constitution we have a specific act which deals with sexual harassment happening to women at their workplace. It also gives you the prevention aspect, prohibition aspect, and redressal aspect. This particular act came into force in the year 2013. You may have a question then what was before that? So before 2013, we had 1997 judgment, that is Vishaka versus State of Rajasthan. So this is considered to be one of the important judgments in the field of sexual harassment at workplace. As you will learn your legal subjects, you will definitely know about this particular case, being a part of Bharatiya Nyaya Sanhita or gender justice or any other statutes and subjects, you will study about women and law. So Vishaka versus state of Rajasthan, if I just have to speak about a little bit, it's basically about a social worker who went to perform her work, that is to stop child marriage, and because of that, because of the social scenario at that time, unfortunately she was raped at her workplace. And later on this case was taken up to Rajasthan High Court, and further it went to the Supreme Court. Vishaka is not the name of the person, it's basically the name of an NGO who took up that case, because in the judgment of the High Court they received an adverse judgment. That means it was not identified as a sexual harassment. So imagine, before 1997 we didn't really have any identified law to cover this particular topic. Therefore, in 1997, in this landmark judgment, the Supreme Court realized that since that in that era, women had just started going out for earning, for work, we were kind of achieving workplace equality. And if during that time, if women are not given adequate protection where they feel safe, we can't achieve the other goals which we have set up for our country. So identifying this need of an hour, in 1997, this landmark judgment came into picture, which gave various guidelines as to how women are supposed to be protected at their workplace. So these guidelines also define how do you define a workplace, how do you define a harasser, everything. And these particular guidelines were useful and are still used as a precedent till 2013, till we actually got a specific act dealing with this particular thing. Therefore, these guidelines play a vital role in deciding all the matters which are related to this particular topic. And then we have Indian Penal Code, which is now Bharatiya Nyaya Sanhita, BNS. So I'm not going to go in detail with regards to BNS, because it definitely has different sections which are covering women and child related issues. So workplace harassment or sexual harassment is basically a behavior which is unwelcome, sexual in nature, and it is a subjective experience. That means you can't decide that okay, particular kind of an experience will be same for person A and person B. So subjective means that itself, that it may be different for different people. And over here in these kind of cases specifically, the impact and intent, two things are really important. So over here we talk about an impact of an activity rather than the intent of the offender. So this is what you as law students need to understand. And it usually happens specifically in workplaces. It's basically about matrix of power. Then we are going to see what constitutes to sexual harassment. So firstly, classic definition as the act gives, that is physical contact or advances, or demanding or requesting any sexual favors, or showing pornography, or sexually colored remarks which are not welcome by any woman. The act also defines what exactly is a workplace. So the workplace definitely, as its classic definition, talks about any office or anywhere where you go to work, but it also includes colleges, universities, and as I just stated, as classic definition of an office. Therefore, as university students, you are learning about this particular session in your orientation itself, because the act also covers college students and all women who are going out to either learn or to earn. Then who all are covered under this particular statute? All full-time employees, temporary workers, contract workers, daily wage employee, trainees, interns, contractual workers, housekeeping, security, client representative, vendor representative, volunteers with or without remuneration. So all the aspects which come under a workforce or workplace criteria are covered under this particular statute, which is also applicable to all female students. Okay, yeah. Then there are certain examples of sexual harassment, that is staring or obscene gestures, showing sexually obscene or suggestive signs, indecent comments, dirty jokes, using power positions to request for favors, touching, petting, and brushing against someone's body, blocking or following, etc. It also covers, referring to a woman with some other name, or, making comments on her appearance, making work discussion or college related discussion sound sexual, then telling sexual nature jokes or stories, and asking about preferences or experiences, or spreading lies about a person in sexual nature, or touching person's clothing or stalking, or apart from all of this, physical assault or rape. So all of these activities do come under this particular act. What is meant by an unwelcome behavior? I just stated in my previous slides that any kind of unwelcome behavior constitutes to sexual harassment. So any conduct or behavior is unwelcome if the recipient doesn't consent to it. So whatever you may feel that this particular kind of behavior is not good, or I don't feel comfortable with this kind of behavior, then that will come as a part of unwelcome, because in the previous slides itself we have seen that it's the impact which is important rather than the intent. Okay, so even if the victim does not complain, it is not necessary to imply that the conduct was welcome. Then some comments and advances are blatant and crude and inherently offensive. Even these can amount to sexual harassment. On the slide, you can see what behaviors constitute to unwelcome behavior and welcome behavior. So any behavior from any other person makes you feel bad, or feels one-sided, feels powerless, power biased, unwanted, illegal, invading, demanding, or which causes anger or sadness or triggers some emotions, or causes any negative self-esteem. All these behaviors can be termed as unwelcome sexual behaviors. Whereas welcome behaviors make you feel good, reciprocal, you feel that you have control over a situation, you have a feeling of equality, you feel wanted, you feel that the relationship or the behavior is legal in nature, it's open, it's appreciative, you feel happy about it, and it generates positive esteem. So this is basically a characteristic of categorization of behavior. So at any time, if a victim is feeling any kind of unwelcome behavior mentioned on these slides, that can amount to sexual harassment at workplace. Sexual harassment at workplace can be categorized in two groups. It can happen in two ways. So first one is quid pro quo, and the second one is hostile environment. So first category is basically this for that. So if you have done something and as a reaction someone behaves badly with you, that can be termed as this category. Whereas second category is an indirect kind of an harassment where hostile environment is created, and due to speech, conduct, or remarks, the person feels intimidated or harassed. So both these behaviors amount to sexual harassment at workplace. Now, since we have understood what exactly are these activities, we also need to understand how you are supposed to raise voice against it, or how you are supposed to get a redressal for these activities. So firstly, as it's stated in the law, that there has to be an internal complaints committee, which will have a presiding officer, 2 members, and 1 member from an NGO. Once you file a complaint, that has to be within the 3 months time span. So from the date of the incident happening. So within the time frame of 3 months, you can file a report. Then the report goes to the internal complaints committee. The committee will further notify the respondent within the next 7 working days and get a response in the next 10 working days. So if the respondent agrees, then maybe the matter can be further processed for settlement or punishment, and then within 60 days the action will be taken. If the respondent doesn't agree to the allegations, then the further inquiry and evidences will take place that can last up to 90 days, and again whatever findings and recommendations are submitted to the internal complaints committee, accordingly the settlement or the punishment, either of these two actions can be taken. Now, what are the consequences of sexual harassment complaint? So once the complaint is received, the investigation has been carried out, the validity of the harassment allegations will be determined. And if the harassment has occurred, prompt and remedial action will be taken. This all is stated in the 2013 Act. The action or the consequences of any sexual harassment act can include restoration of lost items, disciplinary action like warnings, demotion, etc., depending on what kind of harassment has taken place. Since we have understood what exactly is sexual harassment, we also need to understand what is not sexual harassment at workplace. So when someone is following up on your work, so since we are talking about college and university, if someone is asking you to submit the assignments or following on the work or your absence, so that cannot amount to sexual harassment at workplace. It also covers requiring performance and work standards. So if someone is expecting a particular standard of work from you, and if you're not up to that standard, then if the person is asking you to do that work, then again that is not sexual harassment. Then someone asks you to meet the targets of the group or any task which has been given to you, and a person is asking you to fulfill that task, or the deadline, then that is also not sexual harassment. Then work related stress like meeting deadlines or quality standards, touching, brushing against a person, pushing without any sexual intent, that you are passing by and due to too many people are there in the room or something like that, because of that unknowingly brushing or touching or pushing against a person happens without any intention, then that also amounts to that doesn't amount to sexual harassment at workplace. And constructive feedback about your work. So if someone in authority or your peers are giving you a constructive feedback that you have gone wrong here, or you should do this better, this is how you can do it better, so which is for your growth, so all of these things also do not amount to sexual harassment at workplace, because as students we should know what is wrong and what is not wrong as well, right? Then next is how to stop it. What steps can you do? So if you think that if you're facing sexual harassment at workplace, please do not ignore it. Please report it to the person who are in authority. Do not pretend that it did not happen. Report the incident. Do not accept the other person's behavior, because all these behaviors which we mentioned in our previous slides, all those behaviors are unwelcome in nature. Then be supportive. If you know someone that who is undergoing sexual harassment at workplace, please be supportive to them, guide them to file a case. If they are not comfortable filing a case, even as their friends or colleagues, you can take action on their behalf. Lastly, consensual relationships do not amount to sexual harassment, because over here both parties in the relationship are giving consent to the activity. Therefore, consensual relationship do not amount to sexual harassment. But in that also, if you have given consent for one thing but some other thing is happening, then and that behavior is not welcomed by you, then that amounts to sexual harassment. And if consensual relationship ends, then after the ending of that relationship, anything happens after that, that definitely amounts to sexual harassment at workplace. So either person may end the relationship at any point of time without the fear of losing any academic advantages or anything. That is completely separate from these activities. So that's where the presentation ends. You as students of NMIMS need to understand that NMIMS has zero tolerance policy towards any kind of sexual harassment between the staff, teachers and the students, and vice versa. So make sure and you be sure that you are definitely at a safer place. We all are here for you, and we in our university also we have internal complaints committee, and all these details are very much there on our websites. So make sure that you are not causing any unwelcome sexual behavior towards somebody else. And if you are being a victim, then please speak up against it. Thank you so much.
Thank you so much, Dr. Aksha, for giving an insightful session on POSH. And I hope that our students, they must have taken all the provisions very carefully and seriously so that you can defend. If something happens, you can always in a position to defend yourself and to protect yourself. So now with this, we are done with our sessions with the orientation program. And from tomorrow onwards till 27th, you will be having induction program where you have to come to the building, this old Mukesh Patel building, opposite to Juhu Millennium Resort. So you have to come to the classes for the sessions, and there is a small change in the schedule. Now timings are changed due to heavy rainfall, so you have to follow the changed or the revised schedule. So as per that schedule, you please come and attend the sessions. Thank you so much for being wonderful audience. Thank you.
Thank you.